So hello everybody. So we are here with Ken Pope. I asked him and he kindly respond to our request to have a special presentation to us today. Just because he has 30 years of experience working with families with disabilities. And to be honest, I was putting in my calendar for a while to go and to speak with him about my future.
That's how it always works.
Yeah, but with the tax season and merger with KPMG didn't work out. But anyway, I knew about Ken because the community living Mississauga is sending our webinar like in a very with their emails, informational emails, and because one of my clients actually recommended him. So Ken.
Okay, thank you very kindly. And I'll mute you now. If you want to step in and say a few words, just put something into the question and answer box and I'll unmute you, okay? I'm just trying to mute. Ask to unmute. Looks like you may have to unmute yourself, Kirill. So that said, thank you for the invitation. That's very kind. I can see that I'm working with a lot of knowledgeable people here who are particularly busy perhaps this month doing trust tax returns. Obviously, that's a substantial part of my work. My practice specializes in dealing with families with kids with special needs or disabilities. And it's a very enjoyable practice. I'm working with a lot of great families. My practice is a provincial and interprovincial practice. It's definitely not an Ottawa-based practice. And I'll show you the numbers here briefly just to show you the scale of what's going on. And I have sort of a checklist of initial things that your steering committee here thought that would be of first interest. So once I've given a little bit of context here, I'll speak to these points first, and then I'll talk to the other points. If you have questions, please do ask, and Karen will answer a number of them, and I'll try to keep an eye on it. What we'll do is I'll try to shorten my presentation so that I have some time at the end to actually just go through and answer more questions. This is a calculation. You can see here that these are numbers as of February 2020 from ODSP statisticians. They've always been very helpful in providing statistics. Each year, of course, the bottom line, the number of people on ODSP increases, but then again, so does the population of the province. And it's interesting that it's 1 in 10 that is a parent, essentially a parent household, or when the parent is gone, a sibling household that has a special concern for the child. And this is a list of all the people on ODSP. You can see down here, this is the added up categories. And you can see that the population of the province is 13.7 million approximately. That is broken down if you divide it by 3. StatsCan says that that's how many households there are, which is sort of, sounds intuitively correct. So you can see there that if there are 378,000 people between the ages of 18 and 65, and then if you factor in a number for all the kids under 18 and the seniors over 65, that's about a third again. So simplistically, if you were to add 100,000 people, you'd have 478,000 compared to the number that is a tenth of the households, which is 456,000. So you can see that it's easily and conservatively calculated that it's 1 household in 10. So you're not really crazy and alone. And this is a breakdown that they've provided as to the types of disabilities or special needs. What we don't know, for example, is where autism would fit into this spectrum, this pie chart, and or for example, traumatic brain injuries and so on. So it's not really unpacked in some ways, but this gives you an idea. And these are the numbers for any given municipality. You can see here that in Ottawa, here, Ottawa has a population of about 1 million. That's what the sign on the road says. So that would be 333,000 households. You can see here that as of February 2020, there were 25,496 people on ODSP. If that were a tenth, then it would be 254,000 households instead of 333. But then you see there's also assistance for children with severe disabilities, which doesn't really reflect severe disabilities. It reflects a household with a child with disabilities who's under 18 and who receives ACSD. You can see at the top of the column, assistance for children with severe disabilities, but it's based really on household income. If you have a modest household income, you could receive about $450 a month for that child instead of the ODSP benefits that are received after age 18. Now, I think I'll speak to these first points first. There was a question about the fairly recent Canada-Ontario housing benefit for ODSP applicants or recipients. And so I did a small amount of research. And my take on that is that it's not going to be it's going to be of very little use to my client families because their kids are such a low priority. It says here that that the priority will be given to the following groups: survivors of domestic violence and human trafficking. That's not my clients. Indigenous persons. Well, yes, I have some Indigenous clients. Persons with disabilities requiring modified units. Okay. And then finally, households on the centralized waiting list with the oldest application dates, which means that this is just standard procedure. Your child turns 18, perhaps they have some cognitive disabilities. You're involved with Developmental Services Ontario. You apply for ODSP 6 months before he turns 18. You use the letter from DSO confirming that they say that he's one of their clients, and you present that to the ODSP intake, and you can avoid the medical application paperwork that has to otherwise be signed by a doctor, because it's a settled fact that you're medically approved for ODSP. So then they do a very good assessment of you, and they'll put the child onto a housing waiting list if you wish. So then they manage this list, but of course the child's not going anywhere because they're home safe with you, right? So until there's some crisis, such as like for example, parents die, or for example, client family just a short while ago, last year, their boy quickly got a placement. Well, the reason was that the mother was diagnosed with cancer. So she's finished her treatment, and she's waiting for stem cell surgery. So that that's the crisis that made that different. As a result, people, of course, families try to do self-help procedures. They consider giving their home to community living if they'll take care of their daughter. Well, that doesn't happen much, because community living doesn't need the bricks and mortar. You just can't accept a house in which the child lives and a couple others perhaps stay with them, and then automatically get funding from the province for that child. You've got your budget, you've got your funding, and that normally doesn't work, although it can work, for example, but as a rule it doesn't. And there are people talking about getting together, and between the three families with the similar kids with similar issues, perhaps they'll have a shared arrangement. That can happen, that can work. But you can see that something does finally happen, because you can see here that the borders numbers, 48,000. That's the total number of people still at home who are over 18. So that's about 14%. So something happens to the other individuals. Next item, government assistance for housing. Well, there are geared to income units, that is true, but that's why you're on a waiting list. I had a client one time in Kingston, for example, and his child was on a waiting list, and he was capable of living essentially on his own. And so he was on a waiting list to get into a RGI, rent geared to income unit. But of course, that waiting list is very long for any single individual who happens to be living at home with their parents. So we discussed this, and I pointed out that that if the child was in fact in a geared to income unit, all that really happens is that their ODSP, the maximum ODSP, and we'll get to this in a second, is $11.69 a month, and $496 of that is the shelter component. So if you're in an RGI unit and based upon the $496, they decide that your rent will be $135, because that's more or less how they do it. Well, what that means is the $496 is reduced to $135. You're not further ahead. You're just in a unit that you can afford with that amount of money. And of course, the problem, part of the problem with this is that this may be a geared to income unit in a building or a part of the community that you don't want your child in, because it's not restricted to your kid, all sorts of people. So then, of course, the father said, oh, well, instead of waiting for this to happen, I'll just rent a reasonable small apartment close by and pay the difference. And that's, of course, that's what he did. So what the solution is for these families that we're speaking with here, that'll be interesting. But there's a variety of solutions. We've had special webcasts that are specifically directed towards housing issues, transition issues. There should be a replay of the housing webcast on my website under the videos, I would think. Let's see, next item, guardianship and power of attorney. I'll take you to those slides. There we go, starts here. So my understanding from speaking with Corolla is that the parents taking part here, that for the most part that their kids are under 18. Well, if you're under 18, simplistically, the child is, even if competent, is not old enough to have an effective power of attorney for property. That's 18, and power of attorney for personal care is age 16. So if you do have a competent child, then yes, you should certainly have power of attorney, because when they turn 18, when they become adults, of course things change. They no longer see their pediatrician, so you have to find a new doctor, and you have to explain everything, and you take your bundle of paperwork from all the tests and allergies and whatever medications and all this, and re-educate the new doctor every time. But what happens is they can't tell you anything. You know this better than I do. They can't tell you anything because of the privacy legislation. It's a firing offense. But if you have power of attorney, you have a competent child, or even a close to competent child, then a lot of medical practitioners and hospitals are prepared to hang their hat on that. They'd like to tell you. They just have to have some reason to say, oh, well, here's why it was allowed for me to do this. So a power of attorney is one of the very first things that we do for all of our clients if the child doesn't have a power of attorney, which they don't. But then you get into the question of, well, for most purposes, that's all you need. You can be the ODSP trustee for the provincial benefits. You are already allowed to be the account holder for the RDSP if the child's not competent. If they are competent, then it's technically them that are the account holders, although they can allow you to be one. And of course, RDSPs are a big thing. We'll come to that in a moment. But what happens is that as time goes by, parents come to this awkward age where they're not old, but they're old enough. And they realize that they have a bit of peace of mind because they have done a will with the Hansen Trust. They've taken the financial steps, estate planning steps that they could take. But then they realize that when they're gone, that people aren't going to give the same cooperation to their daughter who, has the power of attorney, but when she goes with the power of attorney and her brother to a bank where the RDSP is being dealt with, or some other matter, financial matter, they look at her with different eyes, and they say, well, obviously in the course of this discussion, it's clear that your brother is not competent to have signed this power of attorney. So then what? Well, at a certain age, people will say, well, I guess I should make a guardianship application. And of course, there's a lot of confusion around this because parents think that they are the guardian. Standard procedure. Well, I'm his parent. I am his guardian. Well, no, you're not. You're his mother. So it's not quite that straightforward. But if you have the privilege of having more than one child, then if they are over 18 and a legal guardian with you and your husband, then when you two pass on, your daughter is still there as legal guardian. And if you don't have that alternate just right now, you can still go through the guardianship process, become the legal guardians, the parents of the child, and then by order later, add in a third party. But you've dealt with most of it. You've established that on competence. You've got the property management plan and the plan of care for health and all these things in place. And all you have to do is convince a judge who wants to be convinced that you should now add in a cousin, for example. Are there any questions about that? See, will any of your webinar be applicable to someone in Saskatchewan? Yes, pretty much everything. This is a piece about powers of attorney for personal. I'll just give you a moment to look it over. And this is for property. And this is substitute decision makers. So if your child is not competent, then the parents are the first substitute decision makers. The problem I find in practice is that there are lots of gray areas where, doctors and hospitals think that they know best, and they don't know best. They don't have any skin in the game here. They're professionals. They're doing their best they can. But, the way I explain it is if you look at the position and the involvement of all the supporting professionals, lawyers, doctors, social workers, all those people, all working hard to try to help. If you look at them compared to the parents, and you look at it in the context of an egg and bacon breakfast, the chicken's involved, but the pig's committed, right? So there's just no way. And that other non-parent professionals know better than the parents, in my humble experience. The problem is that a lot of professionals think that they do. You'll find this, for example, where I'm not trying to label or blame in particular community living, but it's one organization. There's many others that support people. But you'll find that it's a business, it's an industry, they have their own agenda. And, you get to the point where they're not above excluding you or doing things and not telling you, simply because it makes their life easier. So what happens there is that if you have legal guardianship, you stand in the shoes of your child. So what this means, especially from a personal care perspective, is that in order to make decisions, you are the decision maker for that child, and you are the one that has to have informed consent given, to grant informed consent to any kind of treatment. This is a slide about guardianship. Now, we don't try to sell guardianships. We do a lot of them, perhaps one a day, but we don't try to sell them because it's a matter of the fact that the powers of attorney, if at all possible, effective and needed, they're hundreds of dollars, not thousands of dollars. The guardianship is thousands of dollars, everything in. So if there's some practical way to avoid it, we do. Excuse me. If you have a child, let's go back up to the disability tax credit. I strongly suspect that everyone in the group here knows about the disability tax credit. But we have a regular practice enlightening other people, discovering that they don't know about it, or that they do know and they've tried to have the child approved, but they weren't successful, so they gave up. So we regularly get them approved and to backfile the credit. And what the recapture is typically for a minor, the minor annual tax reduction is $2,200 roughly. And you can backfile up to 10 years. So the standard recapture is perhaps $22,000. If it was a family with a low household income, low being, let's just say, slightly over 75,000, they wouldn't receive the child benefit, because the threshold, you may know the number down to the penny better than me, but you know, I use 75,000 as household income. So over 75,000, the child benefit is not paid, or last time I looked. Whereas the Canada Disability Child Benefit is paid up to 150,000 household income. So what this means is that there's lots of households out there that don't receive the child benefit because they haven't applied, because they know they won't get it. But if you don't apply for what you're not going to get, you don't then get, in addition, the Canada Disability Child Benefit, which you would receive. So we often put that back into place and backfile it. And you can see that there would be lots of scenarios where the family is not getting the child benefit, but their household income is such that they would get half of the disability child benefit, which you know, at the maximum, the credit would it's a refundable credit, not a non-refundable, which I'm sure you understand. And so, you know, it's maximum $2,500 a year. If you get half, that's $1,200. For 10 years, that's $12,000. So we do this all the time. Are there any questions about that? My son is over 18. Should I be getting power of attorney over his affairs if I don't already? Yes, you should. Any suggestion for unidentified individuals in Ontario concerned about the financial expense of an assessment, especially for neurodiverse adults? Well, I'll tell you. There are a limited number of capacity assessors in the province, but we have a sort of a short list of assessors that we work with on a regular basis around the province. And you could easily, well, for example, we were looking, last year I think it was, we were looking for a couple of assessors in Kingston. We have them close by anyway, and we do everything by Zoom now, but we were looking for a couple of assessors because you have to have two. And for example, in Sudbury, there's one. So you have to have somebody from North Bay drive up to Sudbury for an assessment, like in the old days. So anyway, so there were these two assessors that we hadn't worked with before because they were brand new. So we contacted them to get a quote for the assessments, and they knew each other, and they both quoted $3,000. So of course we didn't work with them. But usually we have it set up so that it's done by Zoom, and the fee is about $1,000 each, which isn't that bad. And you could, you know, if you want to sort of test the waters, you know, for an even slightly lesser fee, perhaps the assessor could tell you whether a further continued assessment would be useful. There are, of course, situations where, you know, there's fact situations where you would do a power of attorney, but at the same time, just prior to, for example, you would do an assessment of some type. So the disability credit is an excellent thing, but even bigger than that, what it means, and I won't go into the preferred beneficiary election part right now, is that if you set up this RDSP, my advice usually is, you know, regardless of the age of the child, set up the RDSP, get on the list, and then you could contribute if you wish. If your household income is less than 95,000, then if you put in 1,500, the child will get 3,500. If it's greater than 95,000, then 1,000 gets 1,000. So, these are all fine factors, but just as a policy, and policies are so you don't have to think, right? So as a policy, I advise clients to set them up. They can contribute if they wish, certainly, but otherwise wait till the child's 18, file 2 tax returns prior to age 18, nil returns, obviously. And then the government knows what the child's own normal income would be, nothing. And then when the child turns 18, then start to contribute, because the child will get the $1,000 bond as of age 18 if you've done these things. And if you put in 1,500, you get the 3,500. And then over the next 20 years, what happens is this grows. And let me just take you to that chart. So if you start when the child is 18, let's say, or 20, let's say, you're born in 2000 and you start to contribute in 2020. So if you contribute annually and you invest the money properly, which often just does not happen if you're working with a bank, because they have a vested interest and you're not earning income. They want to lend it out themselves at a higher rate, right? So if you're working with a proper advisor, with Edward Jones or Investors Group or some other credit union that hooks you up with Mackenzie Financial, some proper advisor, then what happens is you invest it and one hopes that it would grow at 5%, let's just say. That's not unreasonable. So you can see here that by the time the child turns 60, it's 700 grand. And what you'll find as well, it's just the chart. Yeah. When it totals up to that kind of an amount and then starts to pay out at age 60 over a 23-year period, it pays out $30,000 a year, which is substantial. There was a time before all the recent boom in real estate that it would be unusual for a family to even leave the equivalent of $704,000 to one child. Now, of course, it's becoming more common these days because there's smaller families, one-child families, $1-million homes, and so on. But it's still a very substantial part of your estate planning. I won't go into this. This is embroidery about the aspects of RDSPs. I also won't go into the trust changes, the reporting changes that are going to happen this year. I'm sure you're all aware of that. These are the basic essential words to go into a Henson Trust. What this is an absolute discretionary trust. It's a non-vesting trust, which I think is probably unique because it means that the beneficiary has no beneficial interest in the trust asset. Where else are you going to see that? And there's also a reversal of the even-handed rule, because otherwise somehow or other, just how this is to be done properly, one wonders. But if you're the trustee of such a trust and there's no reversal of the even-handed rule, meaning that you could in fact spend all of it on the life beneficiary and leave nothing for the residual beneficiary, the siblings typically, then somehow you're supposed to have an even hand and not just dispose of it all or invest it such that the capital is eroded by inflation, but it returns income to support the child. You can see, for example, in a scenario where a person marries again, second wife, children from his first marriage. And what he does is he passes on and he sets up a trust. It could even be a Henson Trust. I would make it a Henson Trust, where it's designed to help support his second wife. Well, if it's invested in such a way that it simply maximizes interest income, for example, then the capital will be eroded by the rate of inflation. And if the rate of inflation is 2% over a 30-year period, it erodes half of it, simplistically. Not quite half, actually, it's just shy. So you can see that the kids who get the residue get less because it was, not properly even-handedly dealt with. Whether they really have a recourse, it's another matter. But in this case, it's rebutted completely in the Henson Trust. And there's no limit to the size of the trust. It can own a home. If the beneficiary is approved for the disability tax credit and it owns a home, then the home owned by the trust would qualify as a principal residence capital gains exemption. And even if the child married, it could be a matrimonial home, but it wouldn't be divisible if there was a divorce afterwards, because of course it's owned by the trust, and the child has no beneficial interest. It shall not vest. So you see, you can use this equally for the other children who are married and who have several children. You probably know all these things. And so you leave the half of the estate for your son, the personal injury lawyer, who's on his third marriage and has 5 kids. So what you do is you put that half into a Henson Trust too, and you make him the trustee, or perhaps him and another, so that it's joint to sort of strengthen the position. But otherwise, if this inheritance is kept separate and identifiable, it's ordinarily not supposed to be divisible. But I don't really think that the family law judges care about that. But if it's in this trust and the beneficiaries don't have a vested interest, and it's for him and his 5 kids, I think it's pretty well protected. So it deals with that kind of issue too. You could also use it, for example, where you have a couple who have one child who has autism, and her parents have money. So what you do is you discuss with them having a grandparent trust, so that the share that daughter, the mother of the child, would receive is not received directly by her. It's received by her as a trustee of a Henson Trust. So she's a trustee and she's a beneficiary along with her son. So of course she can access the capital with no limit, but of course you attribute the income to the child in one way or the other, so that you can make use of their personal tax credits. The 13,000 and a bit personal credit and the 8,400 disability credit. So first 21,000 of income on this trust winds up not being taxed. This is much better than any one of you receiving that money and investing it and paying tax on it for the rest of your life. There was a request that I talk about lifetime benefit trusts. These have been law, but not having been implemented final reading, or else royal assent rather, until a few years back. And they just kept getting slipped to the side and prorogued and so on. And what it is, it's another special type of trust that allows you to, if you have a child with cognitive disabilities, to have the RRIF transferred to the lifetime benefit trust. The trustee can only do one thing. He can only buy a life annuity, a qualifying trust annuity, based on the expected lifespan roughly, or age 90 of the child. And what it does is purchases the annuity pursuant to the Income Tax Act. The income is automatically attributed to the beneficiary of the trust who has a cognitive disability, which we know we could do anyway with a preferred beneficiary election, but you don't have to take that step. And the income, however, of course, is paid to the trust and then used for the child. So this is a big thing. You could, of course, if you have a client who has a RRIF and is less than 170,000, and the child is approved for the disability credit, and they have an RDSP, well, of course, they could elect to put the RRIF money into their RDSP. A couple of chunks of paperwork to do this, of course. And of course, if the child, the beneficiary, is not competent, then of course this could only be done by their legal representative, their legal guardian. This is just one sample. One sample. You can see here that this is the simplistic. You'll understand better than most how simplistic this is. But if you have a RRIF of 500,000 and you die, let's just say that you pay tax. You die in December. You've got otherwise a high income. So let's just say that you pay half of it, 50% roughly, in taxes. So the government gets what your kid gets. That's just, you know, unfair. So what the LBT would do is it would buy an annuity, would have a guarantee period. And the way I look at it is, at the very least, you want to get back all of your money, the capital amount. Interest rates are low, so it's not a huge factor, but it is a factor. But at the age of this child, the $500,000 payment would buy an annuity of $24,864 a year for 20 years. And the reason I picked the 20 years is if you multiply that annual amount by 20, it comes up to roughly 500,000. Depending upon the age of the child, you might perhaps buy a 30-year guarantee, perhaps, but and get slightly less. But this is my simplistic way of looking at things. And here are the tax credits at the time that this slide was done. So you can see here that the amount of taxable income is very small. Here's the amount of tax, 22%. And over that 20-year period, just to have a metric, you're paying this number, 14,000, rather than 250. This is a sample here based on 275,000, and you can see that the taxes are zero. Take a look at questions. My son turns 18 in April, and we have been approved for disability. Do we need to reapply each year? And should we keep records of how money is spent? He will be continuing to live at home to not paying housing, not paying housing expenses. Well, let's segue to that, okay? So what I'm hearing here is that he's been approved as of April for Ontario Disability Support Program benefits, ODSP. And what that means is that it's been determined that one of these test supplies it's not quite this simple on the DAU medical package, but that he can't function in a competitive workplace or in the community or handle personal care. And if he's at home, he'll be slotted into 896, which is the room and board amount plus drug and dental. So you can't really switch this right now. Just trust me on that. It would be a tactical mistake to seek the higher amount right now, except under very interesting circumstances, which we could discuss if you wish. But he'll be slotted into 896. About 3 months after benefits are received. So for April, he'll receive some partial payment, May, June, 896. And as of about end of June, early July, we would put paperwork in place, if at all possible, to get this child approved for the higher amount. He can receive gifts from any source of up to 10,000 over 12 months. And the asset test is 40,000. So he could have an asset of 40,000 or less. You wouldn't let it get over, of course, and still get ODSP. Now that brings us to the benefit increase. Let's see if I can find that slide. Well, I'll just speak to that point. So the way it works is, here. Okay, here, this is the slide. So what happens is room and board means that that you provide him with a room plus food, what you do. So what we do is we set up a lease arrangement between the parent and the child. The child pays $550 a month for shelter, because if you're in this category, shelter plus supplementary, well, then you have to contribute for shelter. You can't just keep it all and get free housing. So what would happen is the child would contribute $550 a month to you. You track it, log it, pay it out of the account, so on. And what we also do is we ask whether the child can shop and cook. So it's a question of, although at this point, of course, an under 18-year-old boy, regardless of his circumstances, doesn't shop and cook much, may order in perhaps and go to McDonald's and that sort of thing, but he's not going to be shopping and cooking. So lots of kids, though, do have life skills that they've learned in school. So can your, with a shopping list, even if it's a picture list, could your child pick out the items and fill up the cart? Could he take it to the checkout and tap to pay or pin to pay? And then, of course, you're with them. So you put everything into the car, you drive home. Would he know what to put in the cupboard and what to put in the fridge? And then could he heat things up? Can he nuke things in the microwave? Can he use a convection oven? Can he use a stove? And he doesn't have to do this all the time. He just has to be moderately able to do so. Because, of course, he's still going to have family dinners and you're still going to make the roast, right? So we submit this lease document, which does not result in rental income because you're not in pursuit of profit. So similarly, you can't write off expenses. I imagine you know all this. And of course, he can't use the shelter amount either on his tax return because he's not really paying rent. The increase is $273 a month. And you can see that we just looked at the borders of 48,000 people still at home with parents. Well, when they move out and pay rent, or if they're cared for by a supported living organization, which then receives their ODSP plus core funding, they get the institutional amount of $1169. It's just the parents that don't get it. So although you're providing often 24/7 care, your child receives a lesser amount. Now we've done this hundreds of times. I think the last time I looked was about 800. And we're normally successful, although there are some situations where, it's just not possible. And the bulk of our fee is a contingent fee. So if we're not successful, there's no fee. I think that's pretty fair sharing of risk here. Let's see what's next. It's Q2 by my calculation. The caregiver credit, let's go to that. The caregiver credit is a credit that kicks in when the child is 18 and you are his caregiver. It's not something that has to be approved like the disability tax credit, although it's helpful, saves perhaps having to use a Schedule 5 perhaps if the child is already approved for the disability credit. And it's obviously usable by the parent if they're already receiving the transferred disability credit from the child. But it's separate, and you don't have to be approved for the disability credit to use this. And it's presently reduces your taxes by $1,000 a year. It was, I think, 2012 when it increased from $600 a year to $1,000. So it's not fully $1,000 for the whole 10-year period, but it'll get there. And until 2017, or as of 2017, the requirement that the child lives with you, not you with them, but they live with you, that was removed. So what this means is that, of course, this caregiver credit will apply to your child who turns 18 in April. So as of 2021, you'll be able to use line 30450. It's in the year in which he turns 18. And we were looking at the file, I was just self-doubting a little while back, and a family whose child turned 18 December 29th, and I sort of stepped back to consider whether there was any factor here that I should think about that I hadn't, but it's in the year in which the child turns that age. What I find is a lot of things in law are crystallized knowledge, which is why it's so durable. But things do change, and you have to stay on top of those things. And what I find now is that as I get older, one day I'll be old, that It's not what you know, it's what you think you know that ain't so. So all the things that you thought you knew for the last 20 years, all of a sudden you double check and think, geez, is that still right? Let's see. So what this means, the big news, is that you can see here that up until 2017, only the 48,000 families, roughly speaking, could have used the caregiver credit. But then as of 2017, I think it's arguable that all 378,000 families are caregivers. Perhaps some are not. Perhaps the child is completely estranged or some such thing. But let's just say that it's 378,000, but not 802. That means that as of 2017, all of those parent households can use the credit. So that's 378,000 times 1,000. Now all of a sudden you're looking at a big number. Any questions? Can you use ODSP payments for therapies? Definitely. And that $550 that you get from the child, or all of it, you could receive and accept all of it for that matter. It can be spent for anything for the child. The $550 you could just use it yourself if you want, but for the most part, in my experience, people often receive the $550 and then of course use it for the child's needs, or in some cases they just accumulate it. And what they do then is they either have it in a certain account or a certain investment and use it as required, such as perhaps a seg fund. But then what they do is they either have a bequest in their will of everything in that account, or if it's a seg fund, for example, you designate it just like life insurance to go to the trust after your death. Let's see what else we've got here. Ms. Karen Christie would like to answer this question live.
Sorry, Ken, I missed that.
I'm looking at the bottom of the question list and it says Karen Christie would like to answer this question live. I've just answered it.
Yeah, I pushed it live, but I forgot to finish it. So.
Oh, okay. I've been asked again, I think, my son turns 18, we have been approved. Do we have to keep applying? No, you don't. No, very, very rare that that you would have to reapply. I've never seen it. I've had situations where there's, for some reason, attention is directed towards this child's file, and you have to have new disclosure. And once or twice, I've seen it required that you have to have a medical done again. But I've been at this, particular thing since 1996, and I've only seen it once, maybe twice. It's not like the disability credit where Canada Revenue, for some reason, thinks that autism is going to go away when the kid turns 18. It's 10:02, so we're getting there. Let me just see if there's any last items. This is as of September 27th last year, you could qualify for the caregiver Canada Recovery Caregiving Benefit, which is $500 a week, and this applies to everybody if you have a child under 12, and the child has to stay home from school, for example, because of COVID or quarantine. This happens, right? But it's also applicable for people over 18, especially if they have disabilities. So it could often be the case that due to COVID, your child can't go out to a program, or the personal support workers can't come in. So you have to fill in just as you always have. And this would provide you with some kind of income. Just looking to see if there's anything else. If you happen to have clients who are teachers or owners, municipal employees, workman's comp, WSIB workers, OPG, hydro, these are all provincial statutory pensions. And if KPMG has a pension plan, then you could check it out too, just to see. But what happens with these plans is a woman retires, she's a teacher, she has a $60,000 pension, it's a very nice pension, it's indexed. Perhaps her husband was a teacher too. That's not uncommon. So what happens is the husband predeceases, it's always the husband. And then she passes on. Well, if you have an adult dependent survivor, your child who's an adult dependent with a disability, then they potentially stand to receive, if they are an adult dependent at the time of your demise, half of your $60,000 pension. Now, of course, the complication here is that that's $30,000 a year. And if your child happens to be 55 when you pass on and is with Carrie's place because he's severely autistic, then he, on the one hand, he is potentially better off with the 30,000, but he couldn't possibly need all of it because his needs are very modest. And plus he's not competent to apply for it or manage it. So this is where the legal guardianship comes in again. So in this case, it's his sister up in Thunder Bay. And she'll apply for this pension. And we'll probably have to cut a deal with Carrie's place because, of course, he'll lose his ODSP. So this is still a big thing. And what will happen is even the deal we make with Carrie's place won't be 30,000 a year. It might be 12,000 perhaps. So that leaves, after tax, leaves 15,000. And the boy's 55, so he lives another 20 years. So what happens is the sister, the legal guardian, invests that 15,000 for 20 years at 5%, for example. And then when the boy dies, he dies intestate because he has no will, because he's not competent to sign a will. And then by succession law, his sister gets it. This is, again, never happened before. This is very interesting because there was only a certain year, some couple decades back, when this pension was put into these plans, when the survivor pension was put in. Now, the reason I mentioned any KPMG pension is that some private pensions do have this if there's no surviving spouse. For example, Aviva Insurance, Bank of Nova Scotia. What it is, it's a pension for a dependent when you pass on if you don't have a spouse who is the other dependent. So you might want to just double check with your pension people. It's 5:02. I think it's about time to wrap up. Let's see here. So Creola, can you hear me there now?
We have to unmute her, I think.
Okay. Creola, would you like to say any closing words?
I would like to thank you for presentation, and I encourage everybody that has questions to send it to you directly, right?
Yeah, that would be, I mean, obviously, you haven't asked all of your questions over time. And this is how to contact us. Karen is the woman in the background here. And the simplest thing is to either go to the website and complete the family details form or download one of the ebooks, which will then prompt you to fill out the form, the link that you're given. This then gives us some basic information about the situation, and we can highlight perhaps what should now be done or will hopefully should be done in the future. And then, of course, if you want to have a short chat, we can do that. Then if it is determined that there's work to actually be done and we discuss fees and you wish to proceed, well, then, of course, we'd be happy to help you. I think that's said. That's about it. Thanks for the invitation, Creola. It's been fun.
Thank you very much for attending and being so kindly answering our request.
That's very kind. Thank you. So I'm going to close off here now and end meeting for all. And to all a good night.